Hello, everyone. Thank you for joining. I think we still may have a few here to get on the call, but this is the asset protection presentation. So this is how to guard both your business and your personal assets. Very relevant topic. I did this presentation for some business owners and CEOs a few months ago with Brad Barth, and it was very well received. Again, very relevant. So decided this time to open it up to some others, and I am sure you will walk away with some great information on this. So I do want to thank my partners and sponsors for this, which you can probably see them on the screen, and give them an opportunity to tell you a little bit about them and what they do. They have helped me pull this together, and they are my go-to people in the community to support and provide resources, again, to business executives, business owners, and CEOs in this market. So let's go ahead. Ms. Shannon, you want to start us off?
Sure. Thanks, Heather. I appreciate it. I'm Shannon Muniz, and I'm with Strategic Sales Management. I'm also an advisor with Sales Acceleration, and I work with small and medium-sized companies that are struggling with sales, whether it's the infrastructure that needs supporting through hiring and building sales playbooks, if you will, identifying your processes, as well as actually managing sales teams on a fractional basis. So I've called Orlando home all my life and love helping businesses here in the area.
Great. Who's up next?
Great. Thank you, Heather. Good afternoon, everyone. My name is Todd Porras, and I work for Paycor. We're a 30-year-old human capital management technology company. We work with mid-market companies on their payroll and human resource strategies. Typically, I'm working with these companies to consult with them and provide guidance, and naturally to manage their technology. I live in Claremont. I'm in the local Orlando area, and hope everyone enjoys the webinar today.
Thank you, Heather, first off, for putting this together. I know it's a lot, and especially the world that we live in. We adapt, and I heard the term new normal in a TED talk the other day, and the guy was saying, there is no new normal. This is just our normal. And one benefit of this, I think, for all of us is the mode of content that we are delivering now will forever change. With Brad being in Southern California, it's like he's sitting across from me today. So thank you for putting this together as well, and all of the other partners. As my road sign says, financial freedom just ahead. I am a partner with Northwestern Mutual. Been with Northwestern Mutual for 16 and a half years. Been very blessed and fortunate to serve our community. Grew up in Orlando. Central Florida is my home. I've been called a lot of things, good things, I would say, but anything from financial advisor to therapist to a life coach to a personal trainer. And, I had a client ask me the other day, well, what does that mean? And because if you ask 10 people what financial advising means, you'll probably get 11 different answers. And the best analogy that I can give in describing how I help our clients in the community is by saying, if I was a personal trainer and you came and you needed help and you've never been inside of a gym, I can help the person who has never worked out, all the way to the professional athlete that is looking for that 1% edge over the competition. And so when we're working with our clients, really it's understanding, what type of financial background you have, whether you don't know how to balance a budget sheet, all the way to the most sophisticated investor that is looking for income tax reduction strategies, tax mitigation strategies. Asset protection is one of the big areas that I focus in as well. So any way in how I can help the community is how we can best serve, and we're pretty well versed. So thank you again for allowing us to co-sponsor this, Heather.
Yeah, this is a great service package right here on this screen. Who's up next? Chip. Let me get you unmuted here. Let's see.
There we go.
There we go.
So my name is Chip Redmond, and I am a business broker. It's funny, Mike, we call ourselves advisors too, because we are psychologists and helpers along the way a lot of times. But essentially, I'm a business broker. And what we do is kind of our 4 points is we help people to buy, sell, merge, acquire, and actually become franchises. So, but at the end of the day, we're helping people to buy and sell businesses. We're sort of the matchmakers in our world for finding buyers and sellers that can kind of come together and come to terms with businesses. Transworld Business Advisors is the largest in the world. We've been doing this for 40 years, and we do everything from $50,000 companies all the way up to $50 million companies. And I appreciate your time, Heather Ann. Thank you for putting this together.
Absolutely.
Brad, thank you for your time. And thank you for everybody for joining.
All right. So the man of the hour, Brad Barr. So I won't make this, too elaborate because I want you to really kind of tell everybody about yourself. But here's what I will tell you. Brad is the man, as I said before, when it comes to asset protection. He has done a session for some of my clients and business owners and CEOs that I work with. It was very well received. This is such a relevant topic. So now is the opportunity to share it with some others. Brad actually is a partner with Balf Calderon, which is a law firm in California. He has been working with clients on asset protection for, I'm going to say, over 20 years here. So he has got the expertise, both business and personal asset protection.
Right.
So Brad, thank you so much for taking the time to do this.
Right, thank you.
Yeah, and let's, before I start drilling you with some questions that we've already had sent in here, why don't you go ahead and tell everybody what I haven't already said.
Great. Well, thank you. Thank you very much, everyone. And I do appreciate this. It's nice to have basically a panel of a lot of people who are in the finance industry, because it's really kind of the area that we deal most with our clients is trying to protect their assets. And so it kind of goes back to a basic word of either assets or estate preservation. You got to have what to work with. So it's definitely definitely this is a very good community to be speaking with. So yeah, as Heather Ann mentioned, this is my 22nd year of practice in this area. I kind of got my start back in 1997. I do work with my father, who is the founder of the firm, Harry Barth, and I am now a junior partner in the firm. I have probably 12 or so attorneys, senior as well as junior associates who work underneath me. And we cover a lot of areas from your everyday run-of-the-mill estate planning, estate conservation planning for average owners as well as high net worth individuals, asset protections, both domestic as well as international strategies. I work a lot with nonprofits. We deal a lot with real property transactions. And I'm the supervising attorney in those areas. So I've had plenty of experience in this area, and I'm looking forward to doing the Q&A session. Just so everyone knows, I have not seen the questions in advance.
He is
This is
not.
completely on the fly, so I have no idea how this is going to go, but I'm sure it'll be just fine.
Now, he should be able to answer every single one of these with his eyes closed and in his sleep, but he has not seen these questions.
Okay.
For those of you that have joined, I'm going to ask if you do have a question, because of course I can't ask every question and I don't know what questions you may have. So if you come up with questions throughout the presentation, if you could use the chat function and just send those questions to me, and then I'll make sure at the end when we have some Q&A time that Brad has the opportunity to answer all of those questions. I have also asked my partners in this to make sure that throughout the presentation, they use the chat function as well, and they're able to share their information and any questions that they may have. But again, for those of you on this presentation, this is an unbelievable panel of resources here for anyone who's in business right now. So Brad, are you ready?
Let's do it. Fire away.
All right. I'm going to do this without my glasses on too. All right. First question that was sent in. Does my living trust protect me from liability?
Okay, this is a great question, and I've been speaking in both estate planning and asset protection planning, and this comes up almost every single time. When we're talking about asset protection, we're talking about various different tools and techniques that we use as far as corporations, LLCs, limited partnerships. Inevitably, somebody comes back and says, well, I don't need any of this stuff because everything is inside my trust. That's basically what you're asking for, my estate planning, and therefore everything is protected. And what I've found over the years is that there's some confusion in the marketplace between what type of protections basically a traditional revocable living trust offers. Now, there are as many trusts as the imagination can come up with, and they serve multiple different purposes. But for purposes of answering this question, I'm going to deal with your typical family living trust that's used for estate planning and probate avoidance purposes. And so these are what are called revocable living trusts. And so when you kind of go through a little bit of an analysis and you say, well, if you're dealing with a traditional husband and wife client or someone that's answering the question, you ask them like, well, who made your trust? You say, well, I made the trust, my wife and I. And then who's the trustee? And a trustee is basically the legal owner and manager of the trust assets. And so, well, my wife and I are the trustee. And well, who's the present lifetime beneficiary? Well, you know what, my wife and I are the present beneficiary of the trust. And who has the power to make changes and modifications? Oh, you know what, that's actually my wife and I. We have those powers. And who can put assets in the trust? Well, my wife and I. And who can sell assets? Oh, my wife and I. And so if going through a little bit of an analysis, the light bulb comes on where they realize that a regular estate planning trust and the individual are really one and the same. And consequently, Heather Ann, if they are sued, the trust and the trust contents get sued. So there's no distinction between the individual and their regular living trust. What people confuse is protection from probate avoidance. Okay, great. You can avoid probate and the time and unnecessary expense associated with that. You can be protected maybe from some trust contests and estate contests and power struggles. That offers you protection because you predetermined all those in creating the trust. So it offers those levels of protection. It can create protection for beneficiaries, the second generation, because they are not the ones that created it. They aren't the trustees. It's not their assets. They're receiving everything as a contingent beneficiary. So we can put protective provisions for the remainder or remote beneficiaries, but typically not for the trust makers themselves. So it's a very, very common question. And I also give one last thing to kind of put a cherry on top on this one. And I say, well, you can think of it from reverse implication. If your trust was in fact an asset protection tool, I mean, it was some form of asset protection tool, then why would anybody form corporations? Right? Why would you form limited partnerships? Why would you form LLCs? Why would you go through the added expenses of Secretary of State filings and extra tax returns? And hey, just operate out of your trust because the trust is a protective tool. Well, we all know that's not the case. We still have to have other forms of limited liability entities, as I just mentioned, and then those become part of the trust. And so by reverse implication, you can see that you still need limiting liability tools because the trust itself is not an asset protection device. Okay.
That's good. Yeah, no, that's great.
Yep.
Every time you talk, I learn something new. So
Thank you.
This one has more to do with partners in business.
Yeah.
So if I have a business partner who has liability exposure, am I also exposed?
Yeah, well, this kind of goes back to the use of entities, and there's multiple ways of engaging in business, and the default rule is, Heather, and if you and I just get together and say, hey, listen, let's go do this with the intent of making a profit. Well, we're going to start a car washing business or something like that. We don't go through the process of incorporating and partnershiping and all that stuff. We are basically a general partnership. And so what that basically means is that you and I are in business together without any type of limiting liability between each other. So we have what's called joint and several liability, meaning if you go off and do something, say, hey, Brad, that's a great idea. I'm going to go buy a building so we can have the drive-through car wash with all these pressures. And I'm saying, holy mackerel. And you just incurred $1 million in debt on behalf of our general partnership. Well, I'm now jointly and severally liable for all that by the implied consent. And so, and anything that you do, you get into a car accident on behalf of the enterprise, I'm also responsible for it. So typically, when you're starting off with partners, you don't want to be a general partnership. So now you start looking at the entities. Now you have things like corporations, limited partnerships, and LLCs. Those are your the most common. And now you actually have separation of liability exposure based upon the enterprise. So now if you and I are involved in our car washing business, we create, let's call it an LLC. We each contribute $10,000. We're each a 50-50 partner. Now, anything that happens on behalf of that enterprise, we drying off a car, we scratch it, we crash it, whatever the case may be. Now the enterprise is liable and our investment is limited and our liability exposure is limited to our 50% contribution. So we kind of isolate the liability. Secondarily is that if you have a liability personally, I am now not jointly and severally liable for my business partner's activities. So it's another way of cutting off the liability. So it's there are various forms of engaging in business as business partners. But for sure, a general partner is definitely not the way to do things, right? Yeah.
It seems like the easiest way, right? But it's not the most sensible way.
It's the default, right? It's the default, and it still shocks me that I work with a lot of clients who have various entities. They have businesses, they have property set up properly, but then they also have a general partnership over here with like their siblings regarding a piece of property or something. And it's sometimes they're very good about the housekeeping from a business point of view, but they get a little lax when it comes to maybe on their personal side. And that liability, again, could be unlimited. And some things that you don't even control, as I said, Heather Ann, what if you did it? I get completely blindsided because of your activities, because of that relationship. Yeah.
Wow.
Yeah.
Information. So this one, Chip, you'll probably appreciate this one based on what you do. How does asset protection apply in a buy and sell agreement?
Right. Well, let's first start off with what definition of what a buy-sell agreement is. And effectively what it is, it's a right of first refusal to buy out a partner upon some triggering event. And so why do people even want this? So here again, Heather Ann, if you and I are in business together, you and I get along just great. We're great business partners. We have wonderful symmetry. You're married and I'm married. Let's just say you have some kids and I have some kids. And you and I as business partners get along great. I don't particularly care too much about your husband and you don't care too much about my wife, right? So we want to make sure that if something were to happen to the business, that your portion, your half of the business through your estate plan would traditionally succeed to your husband. Now all of a sudden I'm in business 50-50 with your husband, which I don't really get along with, and vice versa with you with my wife. And so or if there is no spouse, maybe it trickles down to the kids. The kids don't know the first darn thing about the business. Maybe the kids are minors. Maybe the kids are in college. In other words, buy-sells prevent this type of, let's call it involuntary partnership. And so the right of first refusal is a contract that says, Heather Ann, if I were to pass away, you have the first right to buy my interest and my estate must sell it to you. So it's a protective tool among the partners. Okay, so that's first understand what it is. We call them sometimes control agreements. How do you control the business? And there's a series of triggers, and this is kind of where we're able to buttress these agreements to capitalize in some asset protection. The example I just gave you is death, probably one of the most common triggers. One business partner passes away. There's typically a life insurance policy that's related to this whole transaction that pays instant liquidity, which is then used for the exchange. Cash on one side, stock or membership on the other side. So you have death. A second very common trigger is disability, right? Disability or incapacity. So when you are unable to function in your key role, maybe it's loss of employment. There could be moral turpitude issues, kind of like what you saw with the Weinstein thing recently. And one of the areas that could be loss of citizenship, perhaps, or green card status. If you have S corporation, that's again a very big deal from a tax perspective. And one of the things that we like to see is involuntary transfers for the benefit of a third-party creditor, or insolvency in case of a bankruptcy. So here again, if all of a sudden I file for bankruptcy and the U.S. trustee tries to go in and grab my stock because they want to sell it or liquidate it to pay off the creditors, well, that's as a result of my insolvency or that creditor involuntary grab. Again, Heather Ann, you and I get along just great. You don't want to get along with my creditor, My creditor has no interest in running a car washing business, right? And so now you have a hostile partner, which will substantially interfere with the workings and management of the business. And so again, as a control agreement, as a protective tool to the other owners, you want these things to be triggers. And so that involuntary grab, whether it's from a U.S. bankruptcy trustee or from a third-party creditor, that's kind of where we use it as a supplement to asset protection. And in the same vein, it could also be a spouse in the case of divorces. And so if you have community property states where I'm from, equitable division states and common law, like in Florida, here again, if that interest becomes part of a divorce estate, even if it winds up being Heather Ann 50, Brad 25, and my wife Bina 25, now we're in partnership again with a hostile minority interest holder. And if certain decisions have to be made with a majority or supermajority or unanimous, we have a challenge here. And we just don't want somebody else in there. So divorce is another one of those triggers, which I would put under the asset protection category to kind of, again, keep it amongst the partners. Divorces, insolvencies, involuntary grab by third-party creditors. These are all areas that we look at buy sells to make sure that those provisions are properly capitalized on. And then I'll throw one last thing in there as well. This is like the old poison pill option inside there. So, and I'm sure one of the things that we can do with it in the agreement is and even if a creditor wants to try to grab that as an involuntary trigger, you can put certain buyout provisions. So if there is a buyout, since nobody passed away in an involuntary grab, there's no cash coming in from the death benefit of insurance policy. So now somebody grabs the stock, it causes a buy option, and the next thing you know, there's no cash to kind of pay that out. And any cash that is going to be paid out is going to go not to me, but to my creditor who basically triggered that event. Well, you can have different payout provisions depending upon who the creditor may be. So if it's a spousal creditor versus maybe like a third party creditor, you can have different payout terms, not to create economic hardships on the remaining partner. Maybe 5 years over 60 months. Maybe you can make it 10 years over 120 months. Maybe there could be a discount that may apply to a third party hostile creditor because you have the difficulty of dealing with that, which may be different than just between partners. So there's other things in the terms of the buy sell itself, in addition to the triggers, but how those triggers actually get implemented, we can put inside the agreement as well, which all benefits our clients.
Huh. You said the word cash, and cash is, it's one of the buzzwords right now, right? It's like pivot and new normal, and everybody's talking about, cash flow and buildup of cash. So one of the questions here is, if I have a big cash buildup in my business, is that a bad idea? And I'm assuming that maybe the answer to this is a little bit different than maybe it was a year ago, maybe not. Yeah.
So the thing is with entities, and this is where you're going with it, is the cash reserves in the company. And when you're talking about an entity, you have to worry about liability from two different sources. You have what are called internal liabilities and you have external liabilities. The internal liabilities are the liabilities arising out of the enterprise. And a very simple example is if you run a franchise, a hamburger joint, and someone eats a hamburger and gets sick, they're a plaintiff as a result of the enterprise itself. They really shouldn't be coming after the owner because that's a liability that arose specifically through the enterprise. Now, if you are the owner, now the owner itself can be a source of liability, but that isn't answering the question that you're addressing. So now all of a sudden we have someone that ate the bad hamburger. So now you have a liability inside. Well, the first thing you want to make sure you have the appropriate insurance coverage to cover whatever your anticipated losses may be. But now let's say, for example, what if that insurance either is excluded or it's deficient for some reason? Well, what other assets can that internal creditor go after? Well, depending upon what the business is, maybe it's got IP, maybe it's got maybe precious metals in there, maybe it's got some real estate. Oh, but it also has some cash. And listen, all things being equal, I'd rather grab the cash. It's easy. It doesn't require foreclosures, doesn't require special uses and license issues. Just give me the cash. Well, if you only have to keep, and this is hypothetical, let's say you only have to keep $100,000 in there for your ordinary operations and obligations, let's say for a quarter, okay? For 1 quarter of the year, you normally got to have about 100 grand in there to kind of cover it. Okay, so then why do you have $1 million in the bank account, right? Why do you have, well, I don't know. I mean, especially if it's an S corporation, C is different, but if you're an S corporation or even a pass-through entity, you've already paid tax on that $1 million. Why not get it out of where the potential liabilities are? If somebody ate the bad hamburger and they're inside and they can grab anything inside, keep that company running thin, not insolvent. Again, you want to make sure you have enough for your O's and O's, but you don't, if you can get away with 100, then don't keep $1 million. That's all. You can pull that $1 million out and you can make it a members distribution. It can be a shareholder distribution. All that's great. You can always recapitalize it in if necessary. You always can make a promissory, a secured loan back in as a capital contribution if you need the funds. But just to sit there because you have a level of anxiety 1 month, it's ripe for the taking. So we like to see businesses run thin, not insolvent. So again, that's a decision that typically my CFOs and CFOs make together, whatever that dollar amount is. And sometimes it is $3 million because of their payroll expenses and things like that. But the idea basically is to kind of keep it run thin because cash is the most exposed asset. And we don't want to leave it there if it's not necessary. Right.
You talked about, you mentioned, S corps and LLCs.
Yep.
So one of the questions that came in said, can I go from an S corp to an LLC without a tax hit? And if so, how does that work?
Yes. So every state, and they fall into 2 different categories called statutory conversions or statutory mergers. And what I always give the analogy like this, there are, and having had more time, there are some advantages of being an LLC over a corporation. But when some companies start out, they just start out as a corporation, or maybe they speak with a tax professional about organizing a company. Say, oh, you should be an S corporation. Okay. They wind up being a corporation, but there's a better legal structure of how to run a business so long as you're able to do so. There may be some statutory limitations, just like here in California, for example, you'll never see the law offices of Brad Barth LLC. You'll see PC, you'll see partnership, but we cannot be LLCs because the state of California said so. So there may be some state-based reasons, but typically, if you start off as a corporation, there's some deficiencies about that, and it's better off to be an LLC. But if you're a corporation taxed as an S, and we say, well, gee, you'd be a lot better if you could be an LLC taxed as an S. Can that be done? And this is where I got to the statutory merger or statutory conversions. And here's how it works, Heather Ann. I say the corporations, every entity, corporations, limited partnerships, LLCs, have 2 characteristics. You have a tax characteristic and a legal characteristic. So in our example, legally, we are a corporation. How are we taxed in our example? As an S. Corporation S. Corporation S. So what we do is we change you from a corporation to an LLC through this statutory conversion thing, but I did not touch your tax status at all. You're still an S. The EIN is still the same. Nothing changed on the tax side. And so this is how you can convert from a corporation to an LLC. And there are a lot of advantage to that for a myriad of reasons. But this is kind of what we call a Plan F reorganization. It's one of the provisions in the IRC that allows for this. And every state has some form. Here in California, it's a single piece of paper, right? You literally just file it. I want to go from a corporation to an LLC. And I give people another analogy, and I say, listen, you see me here, I'm wearing a black polo shirt, right? If I took this shirt off, my corporate shirt, and I put on a pink LLC shirt, did the person that it's covering change? Did it's still the same person. It's still the same soul. I'm still the same individual. I just took off one garment and put on a different garment. I didn't sell the assets. There wasn't a capital gain. There wasn't a capital event. It wasn't moving assets from one entity to the other. I simply took off my corporate garment and I put on my LLC garment. And that's kind of how this type of structure works. Right? Very possible. And then they're, again, very not complicated to do, but there is a proper path to get it done.
And it varies by state, you said, right?
Yeah, every state has different statutory requirements. The procedures are pretty much the same. We just have to make sure that we cite the proper provisions to do it.
Okay.
Yeah.
Is that common, Brad, to see a lot of companies make that?
Yeah, I think so. I think once they become aware of the benefits of LLCs over corporations, I certainly do think so. As again, having worked in the Vistage and business owner client base for many years.
Yeah.
Once they learn about this, and there's no other prohibition, there's so many more advantages over LLCs as opposed to corporations. That's all. Okay. Yeah. So once they become aware of it, it's like I need to do some housekeeping and get that taken care of.
Can a liability at my business, say from an employee, attack my other personal assets?
Yeah, that's a tricky one because again, employment law varies heavily state by state, and so I'm going to dodge this one just a little bit because I know, like here in California, we are extremely employee friendly. I know the great state of Florida may be a little bit different. Texas a little bit different on how they treat employer liability for employee acts. So depending upon what it is, tax liability, payroll liabilities, I'm going to dodge that one and maybe answer a different question in the same vein. Regarding employee-employer liabilities outside of the employer-employee relationship, like hour and wage and things like that, or taxes. Ordinarily, when an employee is doing something on behalf of an employer, there's a concept in tort called respondeat superior. And what it basically means, it just means that the employer is responsible for the acts of the employee. You know, the master is responsible for the acts of the servant. This is that's the relationship. And so long as the employee is doing something within the proper course and scope in furtherance of their employment, then yes, the employer is responsible for the acts of the employee. Now, there is an exception to that. It's called the detour and frolic. I kind of like that word, detouring and frolicking. Were you detouring and frolicking? And the detour and frolicking is when all of a sudden your employee is supposed to be going from job site number 1 to job site number 2, but somewhere in between job site 1 and 2, he kind of stops off at his girlfriend's house for, I don't know, maybe a half hour, 45 minutes. And then on the way there or on the way back, he gets to a car accident, right? He wasn't going from job site 1 to job site 2. He detoured and frolicked. And something happened in that detouring and frolicking. Now the employer is kind of off the hook, right? So that's one of the very rare exceptions in the respondeat superior world.
Example. A question did come in I want to ask you because it may be relevant to what you were talking about. Can you talk about the difference of account titled JWROS versus TBE, and is that state specific?
I actually have no idea what that even is. That was foreign language. What is it again?
The difference of accounts titled JWROS.
Oh, joint tenancy with right of survivorship. Okay, versus.
There you go. Versus TBE.
Oh, tenancy by the entirety.
There you go.
Got it. Okay. I had to put on my multi-language interpreter here.
Hey, I told you these questions. You didn't know these questions in advance. And this one actually came from one of the attendees. So this is
perfect.
Great.
I know. Okay, perfect. Because Florida actually is a T by E jurisdiction. Okay. So the bottom line is like this. I'll give you the quickie and I'll give you the long answer. Okay. T by E is joint tenancy plus marriage. Okay. That's the quickie for those of you that are on the know. So what is it? Okay, so first start off with, there are multiple ways in which people can hold title to assets. They can hold it as an individual, of course. They can hold it with 2 people in tenant in common. It can be held as joint tenants. And then in places like us in California, you have community property. And in places like Florida and roughly about half of the states, there's a thing called tenancy by the entirety. One of the big distinguishing factors between joint tenancy and tenancy in common is that thing called right of survivorship. And what does that mean? Typically, it just means that whoever lives the longest, they wind up owning the asset. It also tells us about how the property is owned by default. So if you have 3 owners and you see an asset, person A, B, and C as joint tenants, I don't even have to ask you what your percent ownership is. I know that it's a third, a third, a third. It has to be equal, and then there's joint tenancy. Whereas if it's tenancy in common, it can be 80%, 10-10, right? You can have disproportionate. That's one of the distinguishing factors already between joint tenancy and tenancy in common. The second distinguishing factor is joint tenancy with right of survivorship simply just means when I have 3 people, when one person dies, it's now owned by 2. And then when the next person dies, it's owned by 1. Whoever lives the longest walks away with the asset. Now, compare that over to tenancy in common. Even if you did have tenancy in common, a third, a third, a third, when person 1 passes away, that becomes an inheritable asset. That's now owned maybe by the spouse or the kids. It's divisible. So you basically have an inheritable interest that does not exist in joint tenancy. So from an estate planning point of view, there's a huge difference between joint tenancy and tenant in common. And I said that tenancy by the entirety, answering the question, is joint tenancy plus marriage. Tenancy by the entirety is joint tenancy, which has the survivorship component, plus marriage. It only applies between husband and wife. Or I'm not sure if you have same sex there, but if maybe it's between domestic partners. So that part I don't know, but traditionally between husband and wife. So now the asset protection component, why is tenancy by the entirety good? Well, of course, one spouse passes away, the surviving spouse gets it. Okay, easy enough. But think about it from an asset protection point of view. Heather Ann, you and I are 50-50 on a building that we bought. We're not husband and wife, but we go and buy a building together and we take title as joint tenancy. Business partnership, joint tenancy. We each contribute $100,000 and then we sit around for 10 years. That property went from $200,000, now it's worth $1 million. I'm sitting here in the back of my mind saying to myself, gee whiz, I'm certainly glad I have this investment with Heather Ann, because if I were to pass away, my family's going to inherit $500,000 and an income flowing off this building. Well, unbeknownst to me, there's a right of survivorship. So Brad passes away in joint tenancy land. Heather Ann files a single piece of paper called a affidavit of death of joint tenant. And what happens? The property vests 100% in you. What happened to my spouse and kids? They're on the curb, burping and chirping. They get nothing. So you have an unintended disinheritance. As a matter of fact, my estate may get whacked with half of a tax bill from the asset, but yet never get the enjoyment and use of that asset. So from an estate planning point of view, it's very, very dangerous. We do use it, but you got to be very careful. From an asset protection point of view, Heather Ann, it goes back to my joint and several liability. You and I own an apartment building together, right? Now, all of a sudden, I get hit by I have a car accident. My creditors are coming after my joint tenancy asset. Because of joint tenancy, this is the legal part. I own it 100% and you own it 100%, right? Which is kind of weird, right? It's not owned 50-50. I own it 100% and you own it 100%. That's why when I die, you own it 100%. Well, wait a second. You always owned it 100%. That's why, right? So as a result, my creditor can take away my 100%, which leaves you on the curb burping and chirping, right? So it's bad from an estate planning point of view, and it's bad from a asset protection point of view. Now, let's flip over to T by E to answer your question. So tenancy by the entirety now is the public policy behind it is to protect an innocent spouse. So here already, because the pedigree of this, of course, you had a working spouse and you had basically a stay-at-home spouse. The stay-at-home spouse may not have known what the heck the working and hustling spouse is up to. And we want to protect that stay-at-home spouse's interest. So if one spouse passes away, it automatically vests in the name of the surviving spouse. Got that? So you had that same survivorship component where it just rolls to the surviving spouse. No need for wills, no need for trust. Just by operation of law, it automatically vests in the surviving spouse. But so with estate planning, it's fine. Now here's the other thing, which is awesome. From an asset protection point of view, you cannot take away the innocent spouse's interest in a tenancy by the entirety from the creditors of the hustling spouse. So the hustling spouse goes off there and gets him or herself in a whole bunch of trouble. They cannot take the residence away or that T by E asset because you have an innocent co-owner, an innocent co-spouse. So it is a wonderful asset protection tool, but you have two deficiencies associated with this. One deficiency is, well, most banks, they know this, right? So they're going to come back and say, gee, Heather Ann, I want to make sure I'm able to capitalize on my collateral. So if I'm going to have you sign off, I also want the spouse to sign off. So now I have two debtors and a T by E asset, no innocent spouse, right? So you lose the asset protection part there. And then the other thing is like this. What if one spouse is driving the car? This is, again, this driving the car. They're the one that causes the accident. They're the liable spouse. The other spouse passed away concurrently in that accident. So when the one spouse passes away, T by E automatically vests now in the surviving spouse. Well, the surviving spouse driving the car is now the liable spouse.
Okay.
They're going to sue for the, right? And there's no innocent spouse. So now you see the problem there? So that's the other area, right? So it's great in certain circumstances, but it's not the end all be all of protecting assets. I would still recommend other forms of protection around that. But so that's a long way of saying how you distinguish joint tenancy by the entirety. You have to have it only applies to married couples. If you're not married, you will never see T by E associated with that asset. Okay.
Huh, very good.
Yeah.
I have one more question for you, and then we'll see if some more come through. How does asset protection, this is a great one, how does asset protection apply to intellectual property?
Oh, great. Okay, because it goes back to that internal liability thing that we spoke about with the hamburger store. Well, now, especially nowadays, some of the company's most valuable asset is the IP, whether it's code, it's process, it's whatever. It's a book that you wrote. It's the intellectual property. So just like we don't want to put cash inside where the operations are, you may not want to put your IP inside there either. Because remember, if the operations cause the liability, the creditor can go and pick and choose whatever asset they want inside that operating company. So if you have valuable assets, cash, I said, remember, thin the company out, pull the cash out of the hot zone, just leave enough in there so you don't become insolvent. Same thing applies with your IP. Does the IP have to be in there? Or can we put the IP out to a licensing company, right? That license it back to OpCo. And this is kind of the example I come across. And when giving these talks also, I come across people and say, Brad, I don't need any kind of asset protection. All this stuff is great, but I got a corporation. I'm good. I say, okay, great. So we talk about, okay, well, tell me what's in the corporation. Okay, well, I got my building is in there. I have my equipment inside there. I have my cash reserves inside there. I have my IP inside there. I have my inventory in there. What else is inside there? Well, I have my employees in there. I have my liabilities in there, my contracts, my sexually harassing supervisors. I have all the liabilities inside the same box as all the assets. So that's not an example of any kind of asset protection. That's an example of tax planning, because the person that they typically asked on how to acquire assets may have been the tax professional, because they wanted to kind of have one consolidated return, one tax return. But when you look at it from an asset protection point of view, that's terrible, because a liability from your employee, or from the bad hamburger in my example, exposes the cash, exposes the building, exposes the IP, exposes the inventory. And if you don't have your cash, your inventory, your IP, you ain't got a company. Or your building where you're located, location, you ain't got a company. So there's no reason why we want to keep these types of assets inside the same box where the liabilities are, where the employees are, the drivers are, the obligations are. So if we're able to pull the assets out, including the IP, now you have OpCo and you have License Co. You have OpCo, you have Real Estate Co. You have OpCo and you have Equip Co. And if we're able to tie them together through licensing agreements, use agreements, lease and loan agreements, now a liability to OpCo is a liability to it. It does not adversely affect your assets at all. So your company may go insolvent, file for bankruptcy or whatever, but then you can always fire up another company because all your assets are still there and reconnect the dots with the contracts. Okay. You don't have to, this is an example of don't put all your eggs in one basket. That's the moral of that story. Right.
Very good.
Yeah.
Hey, let me ask you, I don't see any other questions that came in, but I'd like to, and we have a few minutes left here. What is something aside from these questions, or maybe ties into these questions, what's some advice that you would put out there, to an audience of, business owners, CEOs, some small, some large, what would you say right now, given what's going on and how things are changing?
I think one very important component that we didn't talk about is that you got to plan before you have a problem. I think that's probably one of the most important takeaways I try to give on all of my talks is that asset protection planning and all these various things, entities, LLCs, conversions, whatever, you need to have the stuff in place before you need it. And I give an analogy of insurance. It's no different than having fire insurance. And we're out here in California, right? So God forbid your house is burning down. You don't then call your insurance professional and say, hey, I need more fire insurance, or I need to get fire insurance. They're going to look at you and say, your house, Brad, is already on fire. I'm not going to give you insurance. It's a pre-existing condition. All of these tools are forms of legal risk insurance. They're called fraudulent transfers, or here in California, other states, voidable transactions. In other words, when someone gets sued, it could be a car accident, it could be a dog bite, it could be a rental thing, it could be, as you said, personal side as well as a business side. When someone sues you, there is a definite time that you got complaint, time certain. Everything that you do subsequent to that is going to get scrutinized. Oh, so why now did you form that LLC? Oh, so why now did you decide to start gifting all your assets to Uncle Bob? And you say, well, because I'm trying to hinder my creditor. Of course you're trying to hinder your creditor. You're not the first person to try to think of that. There's a remedy, and the remedy is called a fraudulent transfer. Your Honor, look what Heather Ann is doing over here, right? She's trying to secret her assets away to try to hinder, delay, or somehow defeat my creditor's claim against her. And if the court says, yeah, you know what, that's right, they'll say, Heather Ann, you need to give all those assets back to Brad, put Brad back in the position that he was before the transfer. We call it a legal set aside. And then the creditor can take it away from you. All right. So if you're reacting, you got big problems. Now, if you're doing it in advance, it's like the insurance. I have the fire insurance, and God forbid my house were to burn down, I would then make a claim and then they would pay me back. I was pre-insured for that event. And now it's no different from a liability point of view. You get the car accident, you have the employee problem, you have the workers' comp, you have the construction guy falling up the ladder, and now they're suing you. Now you already have these protective shields. You've already moved the assets out, and now it works just fine. So and when I give my talks, I probably say this 3 or 4 times throughout about the 3-hour presentation. You need to plan in advance. No fraudulent transfers, no transfers after the fact. It needs to be done in advance. And that's probably the most important takeaway. All these tools are great, but if you're doing it in reaction to instead of proactively, it doesn't work as well. You sweat, I sweat, everyone's sweating unnecessarily because you weren't thinking ahead. But in my line of work, though, 80% of my clients come to me because they're reacting to something, and what bothers me is that, it's like I have such a wonderful things I could do, but I can't be too aggressive, right? Because now you want to make sure the client is able to walk in with at least clean hands. I did this for the following reasons, not to hinder this creditor, blah, 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 blah. So you have to build up an appropriate narrative around it. But when someone comes to me in advance, now we can get really creative, right? There's all kinds of wonderful things that we can do, not only because we're just laser focused on asset protection. Well, the panel we have right here online will tell you there's a financial planning world as well. And we try to make sure that what we do fits within the financial planning. There could be retirement components, there could be education components, there could be life insurance, survivorship components, there could be estate components, there could be business and buy-sell, decentralizing managements, business succession. Those are all components that fit within the asset protection. So it allows us to plan from a much more global and holistic approach, as opposed to, oh crap, I got a creditor coming after me, and now I'm just laser focused. And sometimes the tools that we use aren't always in alignment with the financial planning, right? And so when things settle out, we have to sometimes unwind it. So that would be my biggest piece of advice, that if you're into this stuff, you gotta, just like anything else, you wouldn't get in a car and drive without auto insurance and an umbrella policy, and you wouldn't go into business without being a corporation, an LLC with the appropriate commercial liabilities. This is no different. We have legal tools at our disposal to prevent the takers from those of us that have. Okay.
So, and it's, again, I mean, it's being proactive instead of reactive, and
right.
Something may never happen, but
right.
there's also, a strong chance that something may happen,
right.
and it may be something that, quite honestly, takes you out of business.
Yep, and that's yeah. I don't like, and there really isn't any need to kind of sell it as a, even in the good old United States of America, right? It's never a matter of if, it's a matter of when. And
yeah.
I was talking to a client the other day, and he was talking to his advisor, and he used a great word. He says, we'll call him Bob. He says, Bob, he said, you can sit home and not earn any money and be perfectly safe, or you can get out there, hustle, and make a living, but there's risk associated with that. And so you got to be a player, which means you're going to have opposition, right? And that opposition could be businesses or plaintiffs or whatever. It's the way that when we put ourselves out there as professionals, as landlords, as business owners, there's opposition out there. There are opportunistic people that may want to take advantage of the situation. And so so you got to have the plans in place. And the nice thing about it, as I said previously, with these things in place, we can capitalize on some other areas. A lot of what we do has built-in succession options, built-in estate tax minimization tools, and a lot built-in control options. There are a lot of other benefits of creating entities other than I'm trying to shield it from a creditor. So and those options are more available if it's done in advance. Right.
Mike has a question. So Mike, I'm gonna let you go off on mute here, and I'm gonna let you ask that question.
Hey, thanks. First off, Brad, that was great info. Sorry if you hear my dog barking. Beauty of working from home. Oftentimes, I tell my clients, I've been, like I said, doing this for 16 and a half years, and I tell them, I know I'm not a CPA. I'm not an attorney. I just know enough to be dangerous on the subject matter,
mm-hmm.
right? And so one of, oftentimes we hear, well, I met with the estate planning attorney and I have all these entities and everything is structured properly. I went to dinner with one of my friends. I am not his client. He uses his business card to buy me dinner. If he was sued, can creditors pierce that corporate veil if there's like commingling?
Yeah, we'll go with the old facts and circumstances test on that one, right? That's the old depends answer. Because just because somebody uses a business card, and I'm guilty of it myself, right? I used the American Express because I had to get gas in the car, right? And I was driving to the beach. I don't know. There's nothing wrong with it in kind of like an isolated form. It's kind of like habitual. And then do you deduct it as a business expense? So my CPA, like I actually have an Amazon account. I have my business, and every so often I bought something that was more personal. I actually will put a memo in my QuickBooks, Brad to reimburse. And when I meet with my CPA on a quarterly basis, she'll say to me, did you reimburse it? I said, no. I write a check. And I send her a copy of the check. I reimbursed the company because it's not that he took you out to dinner on a personal thing, used a business card. It's how gross is it or how isolated is it? And then to what extent did he or she write that off as a legit business expense, right? You kind of get that. It's not one act. One occurrence. It's the totality of it all. I used my credit card. I don't keep accurate books and records. Every time I'm with the business, hey, thanks for the business, Mike, instead of Mike, president of Mike Co. It's the totality of all these things together. That's what's going to get you, right? Yeah.
That's great. Thank you.
Yeah. Good question.
It looks like it's mainly just another question I just had as well. I know you're in Southern California. If we have clients that are all over the country, are you, for you guys, can you work with people in Florida to?
Yep. Yeah. So what we do, and it's a great question. I get asked all the time as a visit speaker. I speak nationally, and that's a very common question. There's some things that we can do that don't touch state law. It's kind of like forming a Nevada trust or forming a Delaware LLC would not be deemed the practice of law in Delaware or even in Nevada. But certain things like estate planning and maybe contract reviews, there are certain areas where it's more state specific. So if we're working with a client in another state, Florida, for example, and then there comes a point where we're in an engagement that says, okay, this is kind of like crossing over that line. I know I'm your advisor. I know I'm the one that's kind of planning your overall corporate structure. I am the best person to kind of help you with this. I'm going to have to hire a lawyer typically in your county, wherever that county may be, and get him or her to kind of review it and bless it and sign off on it. So we normally basically, I need to borrow somebody else's license. At that point, we wind up just being a scrivener. There's nothing wrong with me scrivening up something for you, but if it goes beyond practicing law in a state where we aren't licensed, then we would have to contact a lawyer, sign off. We typically pay them a couple bucks for their time. They review it, they give us a letter, and it's a done deal. It's when we have those issues. And there are some times, Mike, when I have clients that say, well, they want to do something. I said, I appreciate you coming out to me, but by using me, I'm actually putting you and or your family or your business in a worse position. You need to go to someone local. The fact that you're reaching out to California although I may have the proper skill set, it's actually worse for you under these circumstances. And that typically falls in estate planning areas. Somebody has to be able to eyeball you when you put that pen on paper for trust contests or capacity issues when you sign that contract. So that's just, I think, from years of experience and working with people, you have to know when to say it. That's too far, right? But also, just kind of giving people that top level view. Sometimes we come back and somebody would engage me on the front end, say, Brad, this is my client's arrangement. What would you recommend? Here's the financials, blah, blah, blah. And we'll come up with a full schematic. I'm not sure, Heather Ann, last time we spoke, I kind of put up that Hank and Wendy map. I'm not sure if we had time for that, but I will come up with a whole recommendations, plans, jurisdictions, ownership, what assets go where. And they say, great, thanks. I take that and I run to my lawyer that I've had a 30-year relationship with. Great, no problem. But you know what? I was at least compensated for the design component on that, right? So the design portion is fine. Take it and run with it. You bought that, right? So you bought that intellectual equity.
That's good to know.
Yeah.
And I'm going to, at the end of this, in a second here, I'm going to share my screen and pull up a slide that actually has all of Brad's contact information. So if someone did want to have a conversation, he's certainly open to spending some time talking to you or any of your clients.
Absolutely.
The one thing that he does that I think is really great, because, everybody's time is precious, right? So I'll give you the contact information, and then if you're interested, someone from Brad's team will actually reach out to you and just gather really what do you want to talk to Brad about and some relevant data, so that the time that you spend on the phone or on a Zoom or however it's done with Brad, you're really getting to the heart of the matter, and just really getting down to what the pain point is and, how he can guide you on that. So.
Yeah, thank you for bringing that up, because that's very true. I do the more information I have on the front end, the more I can prepare and the more productive it can be.
Yeah, you want to be able to have that kind of conversation, not spend the conversation asking the questions. So no, that's great. So I want to thank the sponsors who have shared your information via chat. This has just been really great. I encourage you, like I said, to reach out to Brad or share this. This is going to be recorded, and I'll share it all with you. And you can share this with, anyone that that could benefit from this. I just think the topic is so relevant, and every time I do one of these with you, I learn, at least 10 different things.
Yeah, there's